The unfolding legal drama surrounding Prince Harry's U.S. visa files has reached a pivotal moment that could potentially impact his ability to remain in the United States. A significant development occurred when Judge Carl Nichols of Washington set a March 18 deadline for the Department of Homeland Security to make these controversial documents public, following persistent legal pressure from conservative organizations. The case originated when the Heritage Foundation, a prominent right-wing think tank, filed a lawsuit against the Department of Homeland Security after their Freedom of Information request for access to Harry's immigration files was denied. The Foundation's primary motivation stems from concerns about potential discrepancies between Prince Harry's public admissions of drug use and what he may have declared on his official immigration paperwork. The scrutiny of Prince Harry's visa application has intensified due to his own candid revelations about his history with various substances. In both his memoir and Netflix documentary series, the Duke of Sussex openly discussed his experiences with multiple drugs, including cannabis, cocaine, magic mushrooms, and the psychedelic substance ayahuasca. These public admissions have raised questions about whether he accurately reported his drug use history when applying for his U.S. visa in March 2020. The Heritage Foundation's legal argument centers on a crucial detail: if Prince Harry's visa application shows he marked no when asked about previous drug use, this would directly contradict his public statements and potentially constitute a serious violation of immigration law. Such a discrepancy could have significant implications for his immigration status and his right to remain in the United States. The case took an unexpected political turn when former President Donald Trump publicly weighed in on the matter. Trump declared that Prince Harry would not face deportation under his watch, though his statement came with a pointed personal observation, suggesting he was only extending this courtesy because Harry already had enough problems with his wife. This intervention prompted Niall Gardner, who serves as the director of the Margaret Thatcher Center for Freedom at the Heritage Foundation, to make a direct appeal to Trump, emphasizing how the former president had consistently prioritized border security and the strict application of immigration laws. The Department of Homeland Security has mounted a vigorous defense against releasing these documents, arguing that they contain particularly sensitive information that would reveal Prince Harry's current immigration status in the United States. In their legal filings, the agency has emphasized that public figures, while subject to greater scrutiny in many areas, still maintain fundamental privacy rights, especially regarding their immigration status. They've warned that allowing access to these records could set a dangerous precedent, potentially enabling unlimited fishing expeditions for immigration records of any celebrity. Judge Nichols's evolving position on the case reflects the complex balance between public interest and personal privacy rights. Initially reluctant to order the release of the documents due to privacy concerns, he has now adopted a more nuanced approach. His current stance aims to maximize public transparency while still maintaining appropriate protections for Prince Harry's personal information, leading to the March 18 deadline for document release. The case has broader implications for immigration policy and enforcement in the United States. It raises important questions about whether high-profile individuals receive preferential treatment in immigration matters and how consistently immigration laws are applied across different social strata. The situation has become a flashpoint in ongoing debates about border security and immigration enforcement. The DHS's strong stance on privacy protection extends beyond this specific case. Their argument that public figures retain significant privacy rights, particularly in immigration matters, despite their reduced overall expectations of privacy, speaks to fundamental principles of American law and governance. This position attempts to strike a balance between the public's right to know and an individual's right to privacy, even when that individual lives much of their life in the public eye. The timing of Prince Harry's visa application in March 2020 adds another layer of complexity to the case. This period marked a significant transition for the Duke of Sussex, as he relocated to the United States with his wife, Meghan Markle, after stepping back from royal duties. The scrutiny of his immigration paperwork from this period could provide insights into how his status in the United States was initially established. As the deadline approaches, the outcome of this case could have far-reaching consequences. Beyond potentially affecting Prince Harry's personal situation, it may establish important precedents for how immigration laws are applied to public figures and how privacy rights are balanced against public interest in immigration matters. The case also highlights the ongoing tension between government transparency and individual privacy rights in an era of increasing public scrutiny of both celebrities and immigration policies.